Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip has to do with the due diligence time frame, the buyer's right to terminate time frame, and that time frame being contingent upon different issues having to do with the property itself. So, for example, when a buyer and a seller negotiate through a purchase and sale agreement, what we are seeing is, regardless if you are negotiating on a Georgia Association of Realtors contract form or the RE forms contract form, we are seeing typically a buyer and a seller negotiate for an option contract within the broader context of the purchase and sale agreement. And what I mean by that is typically the seller is granting the buyer the option to terminate the contract within so many days of binding agreement date for any or no reason. And contractually, what that time period is referred to, what that option period is referred to, is either the due diligence period or the buyer's right to terminate period, depending upon the GAR form contract or the RE forms contract. But conceptually and contractually, that time period is the same. It is an option contract between the parties within the broader context of the rest of the terms of the purchase and sale agreement. So, in order for a buyer to make the determination, are they going to terminate the contract or are they going to proceed with the contract through closing, there are a myriad of issues that the buyer would investigate, check out, determine, take a look at to decide whether or not to exercise that option to terminate. Some of these issues could be verifying that the property is in the proper address for the school district. Is the zoning for the property what the buyer is expecting? Or is there any new road construction happening or building happening around the property? Are there any active termites? Is there any active termite infestation in the property? Is the property, the land of the property, is that what the buyer thinks? So a buyer can do, is the roof in good shape? Is it structurally sound? What about general issues with the house? So buyers during this time frame, in order to make the decision if they are going to exercise their option to terminate or proceed with the contract, do all kinds of things in order to help them with that decision. They hire independent home inspectors. They get surveys done. They verify zoning. They check with the school district. They get a roofer out there. They get a termite company out there. They check out the septic tank. They get a loved one out there to see if the loved one likes the house. They check out the commute from the property to their place of work, so forth and so on. Again, any number of things that a buyer may do during this option time frame to help them with the decision of whether or not to exercise that option. So, a couple of the things that in order to assist a buyer with their investigations, inspections of this property to help them make that decision, that you need to be cognizant of. For example, are the utilities on? If the utilities are not on, it might be a little difficult for the buyer to have, let's just say, an independent home inspection to check out the systems of the house. If depending on the season, let's say we're in the dead of winter and it's actually cold, imagine that. Is it feasible for a buyer to check out a swimming pool or check the HVAC, the air conditioner part of the HVAC? So there are all kinds of issues that a buyer needs to take into account when considering negotiating this time frame, this due diligence time frame in a purchase and sale agreement, in order for them to be able to fulfill the duties that they need to fulfill with respect to being able to terminate or proceed. So you guys as agents, when you are showing a property to a buyer and you obviously can see that the utilities are not on, or you can see that there is a swimming pool and you're in the middle of winter, you know, something that would be seasonally related, or something about, you know, if you have knowledge of zoning changing or school districts changing, or you see road construction and need to check out what's going on with, you know, if there's road construction coming through the front yard and that front yard might be taken out, or if the buyer wants to have a survey, so forth and so on, then you need to address those issues when you are negotiating this due diligence time frame in the purchase and sale agreement. Because once it is negotiated between the buyer and the seller, it may only be extended by amendment. There's no unilateral extension of a due diligence time frame or a buyer's right to terminate time frame. So you must address this when you are negotiating for this option for between the buyer and the seller, for the option for the buyer to terminate. So think about this. What we see a lot of times, or if there's another example would be a buyer is buying a home from an investor and there's certain construction issues that the investor has said that he or she is going to complete, and so forth and so on, or a short sale even. This was very rampant during our huge short sale market. So a lot of times, unfortunately, what we see in contracts is we'll see a time frame for the due diligence period, and that is timed from the binding agreement date. That contingency is timed from the binding agreement date and extends for whatever the buyer and the seller negotiate. 8 days, 10 days, 12 days, 14 days, 21 days, whatever. But the timing starts from the binding agreement date and then it ends so many days from the binding agreement date. So when there is something that has to occur, when this due diligence period is contingent upon something else for the buyer to be able to inspect it, for example, utilities to be turned on, what we unfortunately see as a special stipulation as a contract is agents putting verbiage in there that says due diligence to begin upon receipt of written notice from seller that utilities have been turned on. Or this was, again, rampant during the short sale market, where we would see special stipulations all the time that would say due diligence period to begin upon buyer's written receipt of short sale approval from seller. Well, let's think about that for a minute. The due diligence or the buyer's right to terminate or this option does not begin until that occurrence. So let's say that, let's just go with the utilities example. If you say due diligence to begin upon buyer's receipt of written notice from the seller that utilities have been turned on, and in page 1 of the purchase and sale, you put 10-day due diligence period. So let's say we are now 14 days from the binding agreement date, and you still have not received this written notice that the seller has ever turned on the utilities. In the meantime, let's say a buyer finds another property that they want to put a contract on. So they want to terminate this one and then go on with another property. Under what contingency may that buyer terminate? Not due diligence, because with that special stipulation, that due diligence does not begin until that occurrence, i.e. receiving notice that the utilities are on. Due diligence the buyer has no option to terminate. So the buyer is locked in. So you never want to time the beginning of a due diligence period from something dependent upon something else. So does that make sense to you? If the buyer terminates before the due diligence begins, under what provision are they terminating? They can't terminate under due diligence. That time frame hasn't started yet. So instead, what you want to consider when addressing these issues is due diligence to begin upon binding agreement date and to extend for the specified number of days, i.e. 10 days, 8 days, 12 days, whatever the buyer and seller negotiated for that option. So due diligence to begin upon binding agreement date and to extend for that many number of days after whatever the issue is, after buyer's receipt of written notice of utilities being turned on. So let's think about that. If the due diligence period begins upon binding agreement date, and you're 14 days into the contract and you have no notice of the utilities being turned on, at that point, yes, a buyer may terminate under due diligence and go on to another property because you're already within that due diligence. The other issue is, well, you don't want a buyer to spend money on an independent home inspector or survey or, let's just say inspection. You don't want a buyer to spend the money on an inspection until that time frame, until you know, for example, in this example, that utilities are turned on. Well, that's why you have those 8 days, 10 days, 14 days, whatever, extend from the time that you receive that notice. So then the buyer can terminate prior to that if they never get that notice. But after the buyer gets the notice from the seller that the utilities are turned on, then the buyer still has those additional number of days for that option, the option to terminate. So does that make sense? I'm hoping that makes sense conceptually for you. Now, let me help you out with a little bit of verbiage. So in the GAR contract, there is a special stipulation that GAR has written. It's Special Stipulation 331 that talks about utilities due diligence to begin. Again, for the reasons I just explained, I'm not all that wild about that GAR special stip. Sorry, GAR, but I think you're locking a buyer in. But anyway, what that says is, notwithstanding any provision to the contrary contained herein, the due diligence period shall commence on the date the seller notifies the buyer that the following utility services serving the property have been turned on and billing accounts have been established, herein collectively called utility activation. And then you have a check place for water, public sewer, electric, and gas. In the event utility activation has not occurred within X number of days from the binding agreement date, buyer shall have the right upon notice to the seller to terminate this agreement. So in that special stip, GAR has some termination rights in there, but it is not timed from the beginning from binding agreement date. So please consider the first part of what we've been talking about when using this GAR special stipulation, because again, your buyer is locked into that contract until a certain amount of time frame. They can't terminate prior to that. So GAR, please work on that special stip a little bit. Just saying. Just consider that and bring, if you're not with Maximum One, please run any special stipulations by your own broker. Another special stipulation that GAR has with respect to repairs having to be done based on seasonal issues, for example, a swimming pool, it is GAR Special Stipulation 310, repair of defects not found due to seasonal issues. And this one says, buyer and seller acknowledge and agree that the following items in or on the property cannot be properly inspected due to seasonal weather or other conditions. Then there's a fill in the blank for what those issues are. Seller warrants that said items are in good working order and repair as of the binding agreement date. If for a period of X number of days from the closing date now of this agreement, buyer uses such items for the first time and finds that such items are not in good working order and repair, seller shall be responsible at seller's sole expense to repair and or replace any defect in said item at that time. If buyer does not use such item for the first time within that time period, or if the defects which the buyer complains were caused by the buyer or his or her guests or representatives, the seller's obligation to repair or replace such defects of those items shall terminate. This provision shall survive closing. So consider that. Now, there's another issue with respect to the due diligence time frame, buyer's right to terminate time frame, and negotiating of repair items. So, for example, let's say a buyer does have an independent home inspection done, roof inspection done, structural inspection done, whatever. And then the buyer sends an amendment to the seller for the seller to address those concerns. Just because there is an amendment between the buyer and the seller that is open, that they are still negotiating, and you're coming to the end of your due diligence time frame, that due diligence time frame does not get extended due to open negotiations on an amendment to address concerns. That due diligence time frame, that buyer's right to terminate time frame, is a drop dead time frame after which the buyer agrees to accept the property as is. So buyers, if you have an open amendment out to a seller and you have not heard anything back from the seller, You need to choose, are you going to terminate this contract and go buy another property, or terminate this contract and rewrite an offer on this property again tomorrow, or are you willing to accept the property as is? That's a decision that buyers need to make when you are coming to the end of your due diligence time frame. Again, with respect to anything, but especially to an open negotiations of items to address by a seller. So, you agents and buyers, y'all need to consider what items it is that you are asking the seller to address. If it is what I like to call in class as a make it or break it issue, a new roof, a structural issue, something that the buyer absolutely does not want or cannot afford the property if the seller does not address those issues. So again, that's a make it or break it issue, versus something like some rotted wood around a window or something that, yes, it would be lovely if the seller would address it and fix it so the buyer doesn't have to put that much additional money into it, but I still want the house regardless of that. I'm not going to terminate the contract because the seller is not willing to address a couple of items. Those are different from the make it or break it items. So if it is a quote unquote make it or break it item and you have an open amendment out there to negotiate those items, consider the verbiage. This, if you are using the RE forms contract, the amendment during the buyer's right to terminate already has this verbiage pre-printed in that amendment. If you are using the GAR amendment to address concerns with the property, that verbiage is not pre-printed in that amendment, and you'll have to use this GAR special stipulation. And again, RE forms, it's already pre-printed in that amendment. GAR is special stipulation 302, and it states, in the event this amendment to address concerns with the property is not accepted by the seller and delivered back to the buyer prior to the end of the buyer's right to terminate as set forth in the due diligence provision of this agreement, this amendment to address concerns with the property shall serve as notice of termination of this agreement upon the expiration of the right to terminate period set forth herein. So again, to terminate a contract, it is unilateral. Notice is unilateral to terminate. So you only need the buyer's signature. So with respect to an open amendment out there to address concerns, if it is make it or break it issues and you have not, you're coming to the end of your due diligence time frame, you have not heard anything back from the seller, you either need to include that special stipulation in that amendment, and that means if you don't hear back from the seller before the end of the due diligence period, the buyer has just terminated. If you don't include that special stipulation, then you need to also prepare a termination agreement for the buyer to terminate the contract. Not to be confusing, but if you do use that special stipulation on the amendment to address concerns in the GAR form, that would go ahead and you don't get it back from the seller agreeing to do those, again, make it or break it issues, that would terminate the contract on behalf of the buyer. Now, agents, y'all remember, you still are going to have to come back with the agreement to release the earnest money. That's just the termination of the contract. That does not address the earnest money. So you're still going to have to come back with an agreement to release the earnest money that will have to be signed between the buyer and the seller. And then specifically, more specifically dealing with short sales, not only with a short sale, not only would you want the due diligence time frame extended, but depending on the time frame before you get approval of a short sale, as we know, if you've been in this market for any length of time, you've experienced that time frame could be a short time frame up to an extended number of months. Not only do you want the due diligence time frame extended, you're going to want all the time frames extended, the financing contingency, the appraisal contingency, so forth and so on. So for you maximum 1 agents, we have an attorney written special stipulation to address that. And it states all time frames in the contract and exhibits begin upon the binding agreement date and extend to the specified number of days per provision after buyer's receipt of written approval of the terms of the short sale from the seller's lien holders. This was supposed to be a short video, turned into a little bit lengthy one. Maximum 1 agents, we have a whole list. There are about 6 pages of special stipulations to consider in your contracts that address all sorts of issues. This is just one of them. All other things such as a buyer getting, I can't think of what they're called. Funds, down payment assistance funds. You need to make your contract contingent upon that. We have a myriad number of special stipulations written for us by closing attorneys. They are available for you guys in the reference section of Paperless Pipeline in a document called 2018 Special Stipulations to Consider. There are additional special stipulations for listing contracts. If you are watching this video and you are not a Maximum One agent, thank you so much. I appreciate your watching. Please run any contractual special stipulations and ideas. Run those by your own broker. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.